My experience is mostly like Anita's in the public sector. In Australia, New Zealand, Hong Kong, most of the PIAs that have been done have been for public sector projects and agencies. But I think most of the points that I draw out, and I'm going to try and get across to you, are directly transferable to the private sector. And I, like Anita, I can foresee requirements or at least encouragement and recommendations for PIAs to be conducted in the private sector, and I think a lot of the experience that's been gained in the public sector area is directly transferable. If I can move, sorry, it's the green one, isn't it? Does that work for me? Yeah. As I say, in most of the jurisdictions that I deal with, they are still only recommendations. Many of you will be aware of the UK Information Commissioner's guidance on PIAs issued in 2009. Still in Australia, it's at the level of Commissioner's guidance and recommendations. So we don't have any mandatory requirements yet. A couple of points. First of all, privacy impact assessment is not the same as privacy by design. It can be an important tool in relation to privacy by design, and if it was done early enough, they might be more synonymous. But usually, privacy impact assessments are done fairly well down the track after an agency or an organisation has decided that it is going to do something and has pretty well mapped out the shape of it, and therefore the opportunity to actually influence the design in the course of the privacy impact assessment is somewhat limited. It's also, in my view, a good privacy impact assessment is about much more than just privacy compliance. You do your client no service at all if all you do is tick the boxes on whether it complies with the legal requirements. As most of you will know, when privacy issues hit the fan publicly, the media and the public don't care whether technically you're complying with the privacy law or not. They will see it as a privacy invasion. And if all your client can do is to say, oh, yeah, we've got a piece of paper here that says we're complying with the law, it's not going to wash in terms of the court of public opinion. They actually need to be able to explain why they made the choices they did about the business model, about the technology, about options, giving people options that may not be required by law for opting out or opting in. I certainly try to look in all the PIAs do it much more than just mere compliance.